Okay, and then share. Okay, that should be locked and loaded. All right. So again, this is Simon Casadas, team leader, broker record for the South Bay Torrance office and also the Long Beach Coastal office. Appreciate you all jumping on the call. We're going to be talking about the provision on the purchase agreement under paragraph 11A, which is the statutory and other disclosures advisory, which is 11A 1 through 4. And the reason I want to touch on this is because, again, a lot of agents unfortunately do not understand every element of the agreements. And I just want to reinforce the conversation. That way you know how to articulate the conversation when you are in front of a buyer or a seller and the seller's asking you questions or the buyer's asking you questions. So on the purchase agreement under section 11, okay, statutory and other disclosures, including lead-based paint, hazard disclosures, and cancellation rights, okay? The reason it does have the cancellation provision is there because the buyer has an avenue to exit the contract if the buyer feels that there is a lot of issues with the property based on the reports or disclosures that the seller provides you. All right, so California has created a requirement for all sellers of residential property to introduce or bring into the parameter of what we call disclosures. And disclosures are from a single family residence to a duplex, triplex, and a fourplex. That also includes leases as well, okay? That's townhomes, condominiums, manufactured homes, and even vacant land. There's certain conditions and disclosures that the seller must provide to the buyer. Remember, it's all about disclosures, disclosures, disclosures. No difference than when you started your real estate career. It was all about location, 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 right? That was part of the process of obtaining your real estate license is, you know, as a licensed real estate agent, the importance of finding, identifying a great location for your clients. But now as a licensed agent, there's other aspects to your responsibility, what we call fiduciary responsibility, your due diligence on behalf of either party, the buyer or the seller, is to have a seamless process, right? And make sure that there is a flow to the actual transaction, right? And it doesn't, again, matter who you represent, if you represent the buyer or the seller. But for the sake of argument in today's conversation, it's really defining the breakdown of the provision of the paragraph 11 of the purchase agreement. So I want to dive deep into it because, again, the importance of you understanding your role and how you can exit or how the seller can exit a contract in good faith, but more so the right way of doing so. And this is just one of those segues that allows you to back out of the deal. All right, so the section 11A talks about the TDS, the NHD, and other statutory and supplemental disclosures, right? So the seller is to deliver to a buyer the mandatory forms created by the real estate transfer disclosure, better known as the TDS, and the NHD, better known as the natural hazard disclosure statement, if the property is in a Melrose district or subject to an assessment pursuing to the improvement bond of Act of 1915, the seller must make a good faith effort to obtain a disclosure notice from the taxing authority and to deliver such notice to the buyer. Nothing in the law imposes the duty to discover a special tax or district that actually known to the agent. A Melrose district is created under the Melrose Community Facility Act, which authorizes the district to issue bonds and levy special taxes to finance designated public facilities and services, okay? It also goes into talking about, the additional, if the seller has actual knowledge that there has been a release of illegal substance on the property, or if the property is affected by an industrial or use zone, a zone or district allowing manufacture, commercial, airport use, or a loco within 1 mile of a formal military ordnance location, which may contain potential explosives. This, in fact, may be a disclosure that the buyer must also have. Now, the seller has exemptions from the TDS and the NHD form, and these other obligations include properties covered by a public report. Resale cannot use this as an exemption. Court order sales, probate, bankruptcy, etc. Foreclosures in lieu of, or in deed of a lieu, real estate owned, basically REOs. Transfer between co-owners or spouses. So if you're doing a co-owner transfer or transferring it from one significant other, such as a husband and wife, then they're exempt from any potential disclosures. Disclosures in the transfer TDS do not eliminate the seller's obligation to disclose all known material facts. If certain disclosures are provided after the buyer has made an offer, the buyer has what's called a recession right upon receiving the new disclosure. The TDS form has section to be completed by the seller, the listing broker, and the buyer's broker. A seller is required to deliver fully completed disclosure form to the buyer, and the RPA defines the quote phase as having the seller and the listing broker section completed. It is the buyer's willingness and will be in possession of the disclosure prepared by those closest to the property, the seller and the listing broker, before having to make a decision after whether to continue with or cancel. The sale proceeds to the statutes by leaving off the buyer's broker section from the define of fully completed of the RPA, takes away any incentives of the buyer's own broker to delay the completion those forms in order to extend or stretch out the buyer's right to rescind until the latest possible time. The buyer should be responsible for the buyer's own agent's delay, not the seller, just because the buyer's broker is not treating it as being included in the definition of fully completed. The contract does not in any way excuse the broker from fulfilling the statutory duties. The fully completed definition encourages full disclosure at the earliest practical time, meaning that even if you provide these disclosures before even an offer gets accepted, that's perfectly fine. Now, is it very rare and far that a seller would provide disclosures to a buyer ahead of time before even an offer accepted? Yes. Southern California works a little different than Northern California. Usually Northern California, they have access to what we have, which is the MLS.
Thanks for calling TG Construction.
And the MLS, one second, let me pause someone. And then the MLS allows for all of the seller disclosures to be provided as part of the process before the buyer even submits an offer. It's a little different. And what I mean by that is that there's no rules and regulations. Salvador, ¿me haces un favor? ¿Me puedes traer un poquito más agua? Thank you. There's no rules or regulations. Thank you. No rules and regulations that says that the seller cannot provide you disclosures ahead of time before even an offer is even presented or submitted. Now, you're going to think, well, why would I waste my time on providing the buyer these disclosures without them physically seeing the property? Well, as I mentioned, Northern California works a little different, where they have those disclosures, all of the seller disclosures uploaded on the MLS, and it allows you, thank you, sir. It allows you the opportunity for you to review, no difference than looking at photos. Photos of the property, the description of the property, and all of the ins and outs of the property. With that said, it also provides you with the disclosure, so that way the buyer knows ahead of time, where they stand. If there's something specific that the buyer wants to inquire a little bit more, well, they have the paperwork. Oh, the seller did, some modifications to the property back in 2019. Okay, now you can dive deep into that conversation and ask more questions. All you're doing is just being proactive. Okay. But by providing these statutory disclosures, it just gives you more power and allows you to not waste any time. Because the buyer that is serious will go in there knowing that they have all the disclosures and they're not surprised with something while you're in escrow. I'd rather be proactive and giving the disclosures up front and making sure that the buyer is perfectly fine. If they're not, okay, then they don't submit an offer. They go find another property. Whereas we work it differently, right? We won't provide disclosures until we have an acceptance. And then the buyer may get the disclosures 5 to 7 days after acceptance, right? That's our traditional way of how we handle disclosures here, okay? Sorry, it's super hot today and just feeling it today, and it's hot and feel a little dehydrated. All right, so sellers have a legal obligation to disclose negative information, okay? And it is the good, the bad, and the ugly of this statutory position when it comes to the seller disclosures. And to really give the perspective in the buyer the know-it-all of the property, okay? The seller does so by answering questions on different forms that are given to the buyer for review. Seller may not know all about all of the problems with the property or may not think something a buyer is considered about having to be a problem at all. For example, the seller may have climbed into the roof to discover a crack in a tile or have a crack under the house to discover plumbing leaks. The seller only requires to disclose what the seller knows. Buyers should conduct their own investigation and not rely solely on the seller disclosures, okay? Buyers should conduct their own investigation and not just rely on the seller disclosures for this reason. If the seller provides these disclosures after the buyer signs the offer, the buyer will have a limited number of days to cancel the contract, okay? And it really defines that in this paragraph. It goes into, again, section 11A 1, 2, 3, and 4. All right. So what it really boils down to is you have two positions, right? You go on a listing appointment and you get the seller to sign off on the listing agreement. Congratulations. A day or two, now you have the seller provide you with all the disclosures, right? You're being proactive and you're not waiting till the last minute. And I know that there's a lot of real estate agents, unfortunately, that they wait till the very end after acceptance. Now, what you should do is be proactive and have all this, so that way there's no time wasted, right? Because once you submit all of the disclosures to the buyer, then the buyer has their time frame, right? If it's 17 days, if it's 15 days, if it's 10 days, 7 days, or if the buyer releases that as a condition, which I do not recommend, but sometimes investors, they already know what they're doing. They can care about the condition of the property and they're willing to release that as part of the condition. But we still have a responsibility, ladies and gentlemen, to uphold and make sure that the process and the flow of things goes concise to the timelines of events, right? Typically a 30-day escrow, 17 days to release a specific contingency, and then either the buyer's in to continue with the process or the buyer's out and will cancel within their time frame, right? Which is perfectly fine. At least you're not wasting anyone's time, and now the seller can put the property back on the market or try to find a win-win, right? Because at the end of the day, it's all about, trying to close the deal, right? I know a seller doesn't want to start over again, seller agent doesn't want to start over again. A buyer's agent doesn't want to start over again. We're sometimes in the mercy of the buyer's position, right? The buyer may find, well, you know what? After careful consideration and looking at all of the disclosures, I think I don't want to continue, right? And it can be many variables, right? The TDS, the SPQ, the natural hazard disclosures. Let's just say that you didn't know, but the property falls on the path of the airport, right? LAX is an example, right? Typically, there's a flight path, right? Well, what does planes do, right? There's noise, there's pollution, there's uncertainty, right? But there is a path that the planes approach LAX, right? And you may just be, or the property may fall in that parameter. Part of the disclosures is, there's going to be nuisance, there's going to be pollutions, there's going to be problems with that. It may devaluate the property, whereas somewhere that it's quiet, you don't have that, may appreciate faster, right? But that's, again, certain things that you must provide the buyer. The buyer at the end has to make a decision. How motivated the buyer is, how much the buyer really wants the property, right? But it defines that in this paragraph of the statutory disclosures that the seller provides, right? And this provision also provides the necessary information, that what we call the stickiness of what the buyer is going to be receiving, and more so what the seller must provide the buyer. Section 11A2 goes into the real estate transfer disclosure statement requirements. It's considered fully completed if the seller has completed the section titled the coordination with other disclosure form by checking box section 1. Seller has completed and signed the seller agent section 3, or if applicable, any agent visual inspection disclosure, better known as the ABIT. Acknowledgement of receipt of a copy of the TDS shall be signed after all previous section, if applicable, and has been completed. Nothing stated herein relieves the buyer agent, if any, from the obligation to conduct a reasonable, competent, and diligent visual inspection of the accessible areas of the property and disclosure as section 4 of the TDS or the ABIT. Material facts affecting the value, desirability of the property that were should have been revealed by such an inspection, or two, complete required to be completed by the buyer agent. Okay. So again, just to reference all of your position is, let me make sure everyone is muted, is, part of the segue, part of the process is within a time frame. Once you either get the offer accepted, the seller has a fiduciary responsibility, the listing agent has a fiduciary responsibility, and you as a buyer's agent have a fiduciary responsibility to make sure that you're getting the documents in a timely manner, so that way the buyer knows exactly what they're buying. Remember, at the end of the day, all properties are sold in as is condition, but also the buyer has the right to do any type of inspections, review of documentation. And therefore, if the buyer is good, they'll continue with the process. If the buyer isn't good, then they can cancel under the section in provision, right? And this is usually under 14B, right? 14B allows the buyer to exit a contract because they look at the property and they see that it's going to take a lot to renovate, knock walls, whatever the case may be, but the buyer has the right to exercise and back out and not jeopardize their deposit, okay? Section 11A3 talks about seller shall, within the time specified in paragraph 3 and 1, provide a supplemental disclosure as follows. Unless exempt from the obligation to provide the TDS, complete a seller property questionnaire, better known as the SPQ, and by answering all questions and signing, delivering a copy to the buyer. If they are exempt from the obligation to provide a TDS, complete an exemption seller disclosure, better known as the ESD form, by answering all questions and signing and delivering a copy to the buyer. Okay. So again, knowing your position and providing. So let's just say you represent the buyer. I am the listing agent and I provide you with all of the disclosures, SPQ, TDS, NHD, all of the disclosures. You give this to your buyers review it, and there's certain things on the disclosures that the buyer says, well, these are questionable, and that'll give you an opportunity to get more information, right? Usually if they check yes to any of the items on the SPQ or on the TDS, there's a section that the seller must provide us with additional information to the why. Okay, why was the house painted? Why was the drywall repatched, right? What modifications did you do? Okay, what alterations did you do? What did you do to the property? What are you disclosing that transpired in the property? Okay, all of those are considered material fact. Because here's the problem that I see a lot of agents fall short and ultimately get involved in a litigation or a dispute is when they do not have their sellers disclose. And now something comes up. And typically, who are the best people to tell on your buyer? It's the neighbors. The neighbors. The neighbors are the ones that'll say, hey, by the way, did you know that there was a flood? Hey, by the way, did you know that there was electrical issues that shut off not just our house, but also your house, right? The neighbors are going to be the ones that are going to tell you probably more information than sometimes the sellers do. So it's best, and it's in your best interest to make sure that you have that conversation with the seller and that you're crystal clear that the importance, this is what prevents lawsuits. This is what prevents mediations, arbitrations. These are the documentations that will eliminate headaches sometimes, as long as the seller is truthful and knows anything and all about the condition of the property. Okay. Now, Simon, they haven't lived in the property. These are this property was an investment, and they've been renting it out for 15, 20 years. Okay. Are they exempt from providing these disclosures? Okay. Well, no, they're not exempt. Just because you're a landlord, you're an investor, and you don't physically live in the property doesn't avoid you to disclose. You must know things about the property, right? If you hire a property manager, the property manager on a summary monthly basis will provide you with any issues to the property. Hey, there's a leak. Hey, there's a sewer issue. Hey, there's a toilet backup. Hey, there's water leaking in the bathroom sink, right? Hey, the electrical is not working. The washer and dryer, it keeps backing up, and the water comes back up. Whatever the variables, the seller has to know about it, right? And it's best to be honest and truthful, because at the end, it is something that will help alleviate a potential liability in the future. Because it only takes that buyer says, I was not aware, the seller did not disclose. And, if I would have known about this issue or concern, I probably would have negotiated the offer, the terms, or I probably wouldn't even bought the place. Okay. You don't want to be in that position. So you want to educate your clients to be honest and truthful. And a lot of the questions are very common. Remember, the more you disclose, the better you're going to be, the better you're going to sleep at night, that you did everything in your power to do the right thing, right? At the end, the buyer also has responsibilities as well, right? The buyer has to do their due diligence, get any and all inspections, go and look at the property, play with the light switch, turn on, and just get an idea if this property is good for them. And if the buyer feels compelled that this property is not in the best shape, right? The buyer has some rights. The buyer has some options. The buyer has the time to submit a request for repair, for credit, for price reduction, or cancel the deal. It all depends on how bad and how motivated the buyer is. Because in the eyes of a buyer, they're going to think that the house is about to collapse, right? Especially if it's a new buyer. It's our job to educate. Look, the home was built in the 1950s. The house is 60 or 70 years old. There's going to be wear and tear on the property. But let's see what let's see what the seller has done to upgrade. Did the seller upgrade the plumbing? Did the seller upgrade the sewer? Did the seller replace the roof? Did the seller added insulation? Did the seller upgraded the electrical? Did the seller install vinyl windows? Did the seller install new doors? Has the seller redid the floors? Did the seller put in a water heater or a tankless water heater? Did the seller do any landscaping? Did the seller do any foundation issues, right? Did the seller redo the kitchen? Did the seller do the bathrooms? Did the seller added square footage? Did the seller went up instead of out? Did the seller got an easement involved, right? Maybe it's backs into an alley, right? Or something to that nature that now it's part of the segue of disclosures. Well, under paragraph 11, the statutory disclosures, it's all of that and then some. Okay, so I want to make sure that we're all crystal clear in our position. All right. So under paragraph 11, it also talks about lead base, right? So lead base is any homes prior to January 1st of 1978. So if your home is 1985, do you need to provide a lead base? If your home is 1995, do you need to provide a lead base? Is your home built in 2021? Is your home built in 2015? Is your home built in 2005? Do you need to provide the lead-based disclosure? The answer is no. Okay, no, you do not. Only prior to December, January 1st of 1978. So if the home is December of 1978, then you must disclose the lead-based paint, okay? And what is lead-based paint? Well, it is some type of substance, paint that was used from the early 1900s all the way up into 1978, that it's harmful for anyone with respiratory or children, that if it goes airborne, that may go into your lungs. So federal law requires sellers of all residential properties constructed prior to 78 to provide a buyer with the lead-based paint notice as an attachment to the contract and disclosures of known lead base and lead hazard reports, and also a lead-based pamphlet. The separate federal lead booklet or the state combined hazard book must be given to the buyer with the opportunity to do any additional inspections. Okay, what I mean by that is the buyer can do a test as well. They can have someone go out there and scrape a little bit of the paint, take it to the lab and determine, is this particular paint lead based, right? And for the most part, if it is 78 or older, it probably does, just like asbestos as well. Okay. Paragraph 11C talks about home fire hardening disclosures and advisories, defensible space disclosures and addendum under paragraph 11B, 11C, 11D, and then section A talks about waiver prohibited, waiver of statutory lead and all disclosures under 11.1, 11B, 11C, 11D are prohibited by law. Okay, so what that means is that even though a buyer may want to go in there, you still, as a consumer, still as a seller, need to provide the disclosures. Okay, even though the buyer says, I don't care, I'm still going to buy it, I'm going to tear down the property, you still need to provide this as part of the disclosure. That's what it's indicating. Section 11F, return of signed copies. Buyer shall, within the time specified under paragraph 3L, 4, or 5 days after delivery of any disclosure specified in paragraph 11, A, B, C, and D, and the defeasable space addendum under paragraph 11D, whether it's later return signed copies of the disclosure in any applicable addendum to the seller. Okay. And then section G, as in George, talks about termination rights. Section G1, statutory and other disclosures. If any disclosure specified in the paragraphs, sequential or amended disclosures to those just specified is delivered to the buyer after the offer is signed, buyer shall have the right to terminate this agreement within 3 days after delivery in person or 5 days after delivery by deposit in the mail or by electronic recording. So meaning that if you do provide any additional disclosures to the buyer after the fact, the buyer has 3 days or 5 days, okay? If it's mailed or electronically given to you, meaning by an email, then the buyer has an additional 5 days to do their due diligence and inspections, get a contractor or a profession out there to evaluate the circumstance. And after even releasing physical inspection as a disclosure, and now the seller provides this new material facts, the buyer has 5 days to review or 3 days if it's in person. And now the buyer can back out of the deal, even though the buyer has released that as a condition. So there still may be an avenue where the buyer may back out of the deal only if it's compelling enough that it's something that may ultimately alter the desirability in living or the value of the property. Okay. So let's just say for the sake of argument, you represent the buyer, you're in escrow 15 days, you release your physical inspection because you agreed to on the 15th day. And then on the 17 days, the seller and the listing agent say, hey, by the way, we just found out that there is structural issues with the property. We started noticing some major cracks on the property, and therefore we wanted to do our due diligence and let you know the outcome of it. As soon as that comes, you need to provide an addendum from the listing side to this new material facts. I get this question often. Do we need to revise the TDS or revise it, or would just an addendum be suffice in order for us in your position? Well, it really depends. It really depends on the circumstances, because some sellers may say, look, I already provided the disclosure on the TDS. I don't want to alter that. I'm going to have a separate email or an addendum reflecting on this new material fact. And then we have agents that says, look, let's just make sure that we're clean and concise. I'd rather update the TDS. So the previous TDS will be void, and the new TDS will have this additional, right? The added language in there about whatever findings that the seller has inquired, right? The crack on foundation issues, right? Or stuff of that nature. So it really depends, but you can't force the seller also from a buyer's position that they need to update their TDS. It doesn't say that they have to. It's optional. But as long as they tell the buyer, hey, we have some issues, we're just bringing to your attention, an email, a text, or an addendum, or obviously the TDS or the SPQ can be included as the supplement to this new material facts, and that should be good to go as well. All right, so just remember from a buyer's position that any new material facts about the property, the buyer has a time frame to do inspections. Well, Simon, you know what? We put a 10-day inspection. We don't want the buyer to go in there and get more people to come and see the property. Well, what you're putting your seller and yourself is in a very volatile potential litigation. Meaning, I would just for the sake of the process, allow the buyer to do whatever they want. You know, because this is new information that was brought to your attention. We don't want this to come back and haunt us, and now the buyer ultimately sues us because we didn't disclose or we didn't give the buyer the right to do any additional inspections. Remember, you're not an expert, your buyer's not an expert, the seller's not an expert, the listing agent is not an expert. They need a hire, and if they don't hire a professional, then you want to document that too. It was brought to the buyer's agent's attention and the buyer to do any and all inspections. They chose to continue with the process and not. Then you want to make sure that you back yourself up with a waiver saying the buyer refused to get a second inspection done on the foundation issue, right? Because you're not going to remember 6 years, 10 years on a transaction that you were involved in, but you can always go back to the file and realize, oh, that's what happened. This is what I remember. And then things will start jotting down like, okay, I remember this transaction, and now it makes sense. Okay. All right, so the section G2 talks about defeasable space and compliance. If by the time specified in paragraph 11F, buyer does not agree to the terms regarding defeasable space compliance delivered to seller as indicated by mutual signature on the FHDS, the seller, after first delivering a notice to buyer to perform, may cancel this agreement, right? So again, how do you find out if this property is under the defeasable space compliance? Well, your NHG report will know. The NHD will say yes or no, that if it falls under the DSC parameter. Therefore, if the seller has not provided you with the form, then you can exercise, you as the buyer's agent and the buyer have the right to exercise and send a notice to seller to perform. And if they don't perform on this provision disclosure, the buyer has the right to cancel. Okay, has the right to cancel. It's pretty self-explanatory. It doesn't get any clearer than what I just told you, right? And then again, just going back to the section 11G, it talks about if the transfer disclosure statement, the TDS, the NHD, the LeadBased Paint, the home hardening, defeasable space, and other disclosures specified in 11A through D were not given to the buyer before the buyer made an offer. The RPA requires that they must be given after acceptance within the number of days specified in paragraph 14. Delivery of these disclosures after the buyer has signed the RPA triggers a cancellation period of 3 days from the proposal received, or 5 days if the delivery is by mail or email. If the buyer receives these disclosures before signing the RPA, there is no cancellation period. Okay. So remember, as I said earlier, up in northern part of California, what they do is clever. They provide all these disclosures to the consumer immediately, because then it falls under this different category. There is no waiting period, right? There's no 3 days or 5 days, right? Because you have already provided these disclosures to the buyer, and therefore, if there's no additional inspections or known issues about the property, then they can't come back and says, well, you got to give me 3 days or you got to give me 5 days. Well, no, we provided you all disclosures ahead of time. You reviewed them, you acknowledged them, you sign off on them, and therefore, your provision to release that as a contingency has been requested. And if you don't, then we have the right to cancel you. Okay. Any questions, thoughts, or concerns regarding paragraph 11? Does all this kind of make sense?
Yes. Yep.
Thank you. Yes.
Yes.
Thank you. The buyer.
And if we find something, wrong with the condition of the property after we close, what is the time period, a year or two, to go back to the seller?
Well, yes and no. So the question Salvador is saying is if there's foundation issues after close of escrow, right? That was not provided or was not disclosed to the buyer. Is one, it really depends on the circumstances, because remember, the buyer relieves physical inspection, meaning that the buyer can go out and do all of the inspections, foundation, electrical, roof, plumbing, structural. So once you release that, what you're telling the seller is, look, I am accepting, acknowledging, and approving the condition of the property. Because that's going to be the seller's argument is, look, Salvador, your client released all contingencies. It's not my fault. I did not know that there was foundation issues. You should have had an inspection done. Now, if you can, and it's going to be very hard to prove that I knew about it. You know, if you have a very compelling position and you can prove that the seller knew about it, then you may have an argument to go back and sue or negotiate. That's a prime example, and I'll give you an illustration on that, because that's something similar that's happening with one of our agents. So the agent represented the buyer. The agent found a property that was a flip property. The seller was the investor, and also the seller hired a listing agent. Well, the seller who did the renovations of the property provided all this information, right? You know, it is a renovated property, selling the property is as is condition. Buyer moved in within 4 to 3 months. The buyer started noticing the separation of the vinyl floors. And these were not small. These were huge separation. Then now you can literally see that it doesn't look right. And it just didn't happen in one section. It happened in multiple sections. So the agent brought it to my attention and says, well, you know, tell me a little bit more about what transpired. Because if the buyer released all contingencies, right, you know, it may be a position that it may be hard for the buyer to come back and try to challenge that. Now, I said, why don't you have your client prepare a letter and then more so have the buyer go get an estimate. Let's get at least 2 to 3 opinions and find out, you know, what is causing the separation of the vinyl floors. So the buyer got 2 inspections by 2 different floor companies, and both of them says, you know, the workmanship was done poorly. They didn't use the proper material, and this is the reason with the heat it started separating the vinyl. So 2 estimates were provided, and 2 estimates were now with preparation of an email by the buyer compelling the position, and we ended up sending it to the listing agent. And on the email was basically, you know, we're letting you know what has transpired 4 months after we close escrow on the overall workmanship of the property. And, you know, we want to provide you with first and a second opinion of what ended up happening with the property, and we want this to be taken care of. So that was sent out to the listing agent. The listing agent took several months back. So we ended up getting our risk management involved. Risk management says, look, not a problem. We can send a complaint letter on behalf of the client from an attorney. And that immediately stirred up the conversation where now the listing agent and the seller were on notice. And now we're back and forth in negotiations. So sometimes it's just that little nudge, that little push will, you know, get things moving. Now, we don't know where this is going to land, if the buyer is in the right or if the seller is in the wrong. all we're doing is just trying to figure out if there's a potential to see if there's a win-win. Now, the good news is that the seller, who was the investor, says, look, I'm willing to go there and get my crew to fix it. The buyer says, look, I don't want your crew or anyone from your team to touch this. I want to hire my people, licensed and bonded, who have certified that this needs to be done. I don't trust on the workmanship you've done. And my concern is that the property will be have the same issues in the long run. I'd rather do it correctly. Now, the argument that the seller says, look, it's only a couple of these separations, but the buyer says, no, the whole entire floor needs to be redone, because what's going to happen is it's here, it's there, and eventually it's going to happen somewhere else. So I rather play it safe. I pay premium for this house. I pay top dollars for this house. And the last that I need is that these floors are not in good working order. So therefore, I want to not use you. You can pay us, and I can pay the company to go out there, but that's the only way that we're going to utilize you. So right now they're back and forth on mediation, trying to get that mediation going. So therefore, we can find an avenue of solution. I'll keep you posted if you're interested in knowing the outcome of this, but that's just another prime example. Now, this transaction unfortunately happened after close of escrow, so it changes the trajectory of the position that the buyer has, which the buyer still has a compelling position, right? No new homeowner should be having to deal with problems with the house. Right now, if you buy the property with bad condition of the home, well, of course, there's going to be wear and tear, right? But you expect more when the house has been renovated, right? New plumbing, new roof, and all of a sudden you're getting a leak in the roof or you're getting plumbing issues. It just puts a bad taste in your mind, right? But at the end, it's all about the win-win. The information and providing this to all of the material facts about the circumstance, and then ultimately trying to make a win-win on this, right? And it can go different directions, right? The buyer may propose this and the seller says, look, no, you know what? It's pride of home ownership. Unfortunately, I'm going to clean my hands on this. You had your time period to do whatever you need to. It's just unfortunate that 3 to 4 months later, this happened. Well, that could be the seller's argument. The buyer's argument says, look, I get it. I can see this happening in 10, 15 years, but come on, I just moved to the place. So there's obviously a quality problem that needs to be rectified, and it needs to be rectified immediately, right? So in essence, I want you to understand that we as real estate agents, we don't step into the chaos, even though we're involved in that. This is a dispute between the buyer and the seller. Once the deal closes, we're basically out of the transaction. You don't want to be in the trenches of this process, because now you may be involved and now you have to be subpoena. It's best that the buyer and the seller dispute it. You can provide the necessary information and then let the buyer do what they need to do. Ultimately, in these cases, they should also retain and speak with an attorney as well. So with that being said, any final thoughts before we close it out? I know it was a lot of information, but I appreciate you. And again, if you have any specific questions regarding any of the purchase agreement, I wanted to just break it down, dissect this particular paragraph, because it gives you just an understanding of the pros and cons, and understanding, what the disclosures that the seller must provide and the buyer's responsibility to those disclosures. But as long as they have that as part of their contingency, then the buyer has the right to exercise this paragraph and back out of the deal if they need to. With that being said, I appreciate you all. Thank you very much. And I will see you on the next contract class.
Thank you so much. Thank you.